Welcome to the video lecture series of Project Development and Resource Management. Course code MC301, contact hour 4, credit 4. This is lecture 8. Myself, Dr. Sudipar Roy, Assistant Professor of Electronics and Communication Engineering Department, Guru Nanak Institute of Technology. This is a subject of MTech Electronics and Communication Engineering. So today we will study the module 2 that is present in our syllabus, agreements on trade-related aspects of intellectual property right, what is intellectual property, importance of IPR, patent, types of patents, patentable inventions, application and registration of patent, who can apply, rights and duties of patentee, infringement and remedies. Among these, this lecture will present what is intellectual property, importance of IPR, patent, types of patents, patentable inventions. So let us start with what is intellectual property. Actually, intellectual property is a term referring to a number of distinct types of creations of the mind for which property rights are recognized. Though it is presented that distinct types of creations of the mind, that doesn't mean that it could not be a technical object. It is always come from mind only. Actually, the invention that comes from mind and also from brain that can be implemented in a prototype, and the invention should be a distinct type of invention, that much property. Either it is mind or it is of mind or of brain, that is can be considered as intellectual property. So intellectual property cannot match with one another. It is a distinct property that comes from individuals. Now, what is the difference between intellectual property and intellectual property right? Actually, a right that it had by a person or by a company to have exclusive rights to use its own plans, ideas, or other intangible assets without the worry of competition, at least for a specific period of time. So what does it mean? The difference is intellectual property is itself property, that holds good for a useful purpose. But if the property is of mine and if the property is of distinct in nature, say nobody has this type of property, then I should go for a for an intellectual property right. That is, this property is only of mine, or this idea is only of mine, this concept is only of mine. Nobody owns this property or this idea or this concept. So this is called intellectual property right. This right may be of individual and this right may be of an organization. And when this right is claimed for that period of time, that is considered that it has no competitor, but not that in future it has no competitor. Maybe competition may arise. So moving the next slide. What is the importance of IPR? Actually, why should we go for intellectual property right recognition? Our IP rights can set our business apart from the competitors, be sold or licensed, providing an important revenue stream, offer customers something new and completely different, form an essential part of your marketing or branding, and be used as security for loans. That means loan may be granted if we deposit our property or intellectual property to the bankers. Protect your creation against infringement by others. That is, say, if I have mm, prepared a sculpture. Okay, so that sculpture is so unique that I should go for intellectual property right recognition. So that, say, some years later, someone has come up with the same type of sculpture, that much he or she can't claim that this is his or her idea, totally new idea, because I have already made a copyright of that idea. So, intellectual property right can be of many types. So, this is mentioned over there in the slide, that is industrial design. For industrial design, we may have intellectual property right. For trademark, that is one part of intellectual property right. Trade secrets, that is also an intellectual property right issue. Geographical indication is also an intellectual property right. Patent is also an intellectual property right. And copyright is also an intellectual property right. So let us move to the next slide. It is industrial design. Industrial design, all the designs, maybe it is industrial, maybe it is not industrial. All the designs have its own shape, aesthetic features, configuration, surface pattern of an article. So, typical views are front view, back or rear view, left side or oblique view, right side or oblique view, top view, bottom view, and isometric or perspective view. So whatever the view it has, if it is unique, then this industrial design can go for copyright or intellectual property right recognition. Now, what is trademark? A trademark is a distinctive design or indicator used by an individual, business organization, or other legal entity to identify that the products or services to be delivered to consumers with which the trademark appears originate from a unique source and to distinguish its products or services from those of other entities. That means trademark is nothing but that Google Google this is one trademark. It has a distinctive font. Now the Apple company also has its distinctive sign or indicator. McDonald's has its distinctive sign or indicator. No other company can use this sign or indicator for their purpose. That is the issue of trade. Now, one more thing on which this IPR depends, that is GI, that is geographical indication. A geographical indication is a name or sign used on certain products which corresponds to a specific geographical location or origin. As for an example, this Kolhapuri chappal. Kolhapuri chappal, it has typical design, size and shape, and no other company can use this typical design or aesthetic. They can use obviously, but they have to go somewhere. official procedure. They have to take permission from this IPR agency. Then they can use, if they permit, then they can use this aesthetic or whatever to their shoes also. So this is Darjeeling tea. Darjeeling tea. This is typical Darjeeling tea. Darjeeling tea. Assam tea. The taste of Assam tea, taste of Darjeeling tea is not same. And Dehradun rice. The lower one is Dehradun rice. Dehradun rice is another brand name. No other company can use this name Dehradun rice because it depends. All this depends on geographical location. Rice from Dehradun, tea from Darjeeling, and shoe from Kolhapur. Next is copyright, the exclusive and assignable legal right given to the originator for a fixed number of years to print, publish, perform, film, or record literary, artistic, or musical material. So this is Windows, Microsoft Windows. This copyright, this symbol is dedicated for Windows. No other company can use this copyright. So what is patent? Patent actually depends on novelty, inventive steps, and utility. It is an exclusive right granted by a government to an inventor to prevent others from making terms of the for making a new product or a new process. So there should be a stamp that is presented and no other company can use this product for their purpose. Now, if anybody asks, what are innovation? What are the inventions? Any process for the medicinal, surgical, curative, other treatment or preventing, the mere discovery. Actually, these are not inventions. The mere discovery of a new form of known substance. Mere discovery, new property, or new use of a known substance. A substance obtained by a mere admixture resulting only in the aggregation of the properties of the substance thereof or a process by producing such substance. So what are not invention? Which claims anything contrary to natural law. A method of agriculture or horticulture, this is not invention. Method of playing games, this is not invention. Can't be rather, this can't be invention. Topography of integrated circuit can't be. A presentation of information, it can't be an invention, it can't be a copy, can't have copyright, or can't claim IPR. So, advantages of patent. Actually, a patent gives you the right to stop others from copying, manufacturing, selling, or importing your invention without your permission. So, if anybody uses it, then he or she needs the company needs the permission from the owner. So, it restricts the plagiarism issue. You get protection for a predetermined period, allowing you to keep competitors at bay. You can then use your invention yourself, and alternatively, you can license your patent for others to use it or sell it. As with any asset, this can provide an important source of revenue for your business. Indeed, some businesses exist solely to collect the royalties from patent they have licensed. So these are the references for the IPR. If there is any question, please feel free to ask me to this email ID. Thank you very much.